All right. Good morning, everyone. Welcome. Thank you so much for joining us this morning. My name is Shannon Fuller. I am the Cooperative Resident Organizer at Raise Up Housing Cooperative in Lewiston, and I'm also a member of the Cooperative Maine Business Alliance Steering Committee. This is the second webinar in CMBA's Co-op Month series, designed to empower cooperatives with the tools and knowledge needed to enhance workplace well-being. Today, we're going to be talking about the new Maine Paid Family and Medical Leave Program. We're really fortunate to have Reggie Parson and Khalid from the Maine Department of Labor here to tell us all about it and to answer your questions. So in a couple of minutes, Reggie and Sophia will start with a presentation that they've prepared about the details of the law and the plan for implementation. Then we're going to talk a little bit more about how paid family and medical leave will apply in situations that are a little more specific to worker cooperatives. And then after that, Reggie and Sophia can address any additional questions that you may have. We're going to be using the chat as a place for you to ask questions. However, we're going to request that you wait until closer to the end of the webinar to type those in, unless the question that you have is really specific to a particular slide during the presentation. Waiting to the end to type the questions in is going to help us make sure that we see and address all of your questions. Sometimes the chat just moves fast, and we want to make sure that we capture everything that you're most wondering about. So I will prompt you when it's the best time for you to type those questions in, if you have them. We will be sending out resources and a recording of this webinar so that you can refer back to it later as you're working to implement this and ensure compliance with the new law. We're also going to be sending out a survey, and we would really, really appreciate your feedback on this webinar. You will receive that link in an email, and we're also going to paste it into the chat before the end of this webinar. So if you want to just do it right at the end, that would be wonderful too. So those are my housekeeping items for the beginning, I think. So without any further ado, I'm going to turn it over to Reggie and Sophia.
All right. Awesome. Thank you, Shannon. And thank you again for this opportunity to talk about paid family and medical leave. There's a lot of moving pieces to this law, but we are excited to share that we are making a lot of progress. As a small team of 9 individuals. So we are, during our presentation, going to provide you kind of just with a general overview of things and a little bit about rulemaking and all of that. And then obviously, again, leaving enough time to address any questions you might have. So without further ado, I will go ahead and begin talking about paid family medical leave. And so, yes, and again, this is the agenda of this morning's presentation. So just to start with a general overview. So this is I would say, relatively still new law. But in July of 2023, Governor Mills and the state legislature passed paid family and medical leave, which made Maine the 13th state in the country to adopt a paid leave program. This law will provide up to 12 weeks of paid leave for either family, medical, safe leave, or leave that's related to significant others' upcoming military deployment. This law is going to be pretty broad and far-reaching, so meaning it's going to apply to many employees and employers in the state of Maine. With the exception of the federal government, that was a statutory requirement that employees in the federal government will be exempt from the law. So to provide a little bit of a general timeline on kind of, again, after the law was passed, on October 25th, 2023, that is when the law actually took effect. And so that gave the Department of Labor, which is where the paid leave program is housed, the ability and the authorization to begin the implementation process. So we've been working hard and at very much full speed to meet these statutory deadlines. But before I talk about the rulemaking and the payroll contributions, I'll talk about the Paid Family Medical Leave Benefits Authority. This is a 15-member board that is a pretty new board to the state of Maine. 11 of the 15 were nominated by Governor Mills and confirmed by the state Senate. And the other 4 individuals are from the current administration, and they represent different agencies or interests. But this is a pretty diverse board in terms of having folks who represent either the private sector, whether it's the business side of things or educational side, or, small businesses, large businesses. This is a pretty diverse group, and they have been very active and busy ever since they have been confirmed, trying to stay up to date on what the department is doing with regarding to implementation, and then obviously offering their guidance based on their experiences that the department has considered and will continue to consider. But some other things to keep in mind for January of 2025 is first, the department has to adopt the rules by then. That is a statutory requirement, and I'll talk more about the rulemaking process on the later slide. But another thing that's going to be impacting a lot of Maine employees and employers, and that is the beginning of premium deductions for the program. And that will begin in January of 2025. And then I'm happy to talk more in a later slide about what those payroll deductions are and what does it mean. And then finally, May 2026, that is when benefits will officially go live for the program. So to talk a little bit about the rulemaking process. So even before we began the formal rulemaking process, we did a lot of informal stakeholder meetings. And so in order for us to try to craft a rule that hopefully made sense and reflected the feedback of employers and employees itself, we did informal listening sessions. So you can find those 4 listening sessions on our website on paid family medical leave, and that is at www.maine.gov/paid leave, and you can find those 4 listening sessions, but they touched on different topics. But then we moved into the formal rulemaking process, which began in May. So we put out the first proposed rule after taking in all the informal feedback and trying to help make the statute also make sense, because as part of the rulemaking process, there's a lot of terms and things that are kind of unless the statute is pretty clear, left unknown. And so as part of the rulemaking process, our job was to basically implement the law and make it into something that is concrete and people can actually feel and touch with the application process and the premium contributions and all the things that come in the rule. So that first public comment period led to us having over 1,000 comments and just under 300 individuals commenting. So we had a lot of feedback from that first proposed rule, which was really helpful for us. And as a result of that, we put the rule back out a second time in late August. And with that one, that resulted in about a little under 280 people commenting and just under 600 comments. So people have been engaged in this rule and this process, which also includes a public hearing. We had 2 public hearings on the rule, in fact, so people could come to Augusta and actually in person offer their testimony, if you want to call it that. So to talk about the premium piece, so this is going to be a program that both the employer and the employee are going to contribute to. So the contribution rate for this program is set at 1% of an individual's wage rate. Again, that's split between the employee and the employer. Elected coverage, individuals could elect coverage essentially. So those are either self-employed individuals or tribal governments. And if those entities decide to elect coverage, they'll be paying 50% of that premium rate. But to help people understand what's going to happen in January in terms of payroll deductions and the like, and I can talk more about the Maine paid leave portal as well in this conversation. So if you are an employer with 15 or more employees, we use a general example of $1 million a year. And so you'll see what that 1% contribution rate is. The employer will pay 5,000 and the employees will also pay 5,000, equaling 1%. But if you're an employer with under 15, it's going to look a little bit different. So we use an example of a payroll of about 250,000. The premium rate for a business of this size and employees will be 0.5%. And that can come from that can come entirely from the employee's pay. And the reason why it's 0.5% for businesses under 15 is that the employer of that size is exempt from having to pay an employer share. So businesses of that size, they're still participating in paid leave, but the employer themselves will not have to pay that additional 0.5%. And then two, to talk more about the portal, and this is something that as a worker, you don't have to necessarily worry about, but as an employer, you do. So beginning in early 2025, we'll launch what is called the Maine Paid Leave Portal. This is a portal that every business in the state, including out-of-state businesses with Maine employees, will have to register for. That will give employers the opportunity to self-report how many employees you have, and then also for employers that may want to pursue a private plan, that is where you would apply for that private plan. But again, more information will come from that portal as we're in the process of developing it. But also too, you might be asking, where's all of this money going in terms of premiums? So the premiums are going to be going into the Paid Family and Medical Leave Fund. And that's where that's where the money will come from to pay for benefits or to pay for any administrative costs to operate the program as well. So to talk about the reasons for leave, and again, these are just more general examples. So for family leave, it can be because you're either expanding your family through either birth, adoption, or fostering, or could be related, for a bonding claim, or to help a family member, a loved one with a serious health condition. And for medical leave, this is dealing with your own medical needs. And then finally, for safe leave, this helps individuals to, stay or get safe from either domestic violence or some form of sexual assault or some form of violence, essentially. And the safe leave provisions also apply to the employee or the employee's family member. So that employee could take time off if their family member is experiencing some form of violence, and safe leave needs to be taken. And then finally, any emergencies related to a loved one, could be a spouse, for example, that's an active duty service member, and that other spouse needs to take time off to handle the transition of that. So in terms of the types of leave that can be taken, so individuals can take it for continuous leave where, for example, you're off weeks at a time. And again, that could be either to bond with a newborn or for whatever the qualifying reasons are, you could take continuous leave up to 12 weeks. For intermittent leave, you are, for example, still working, but you're taking time off in increments. So that can be either for medical appointments or, again, for whatever qualifying reason that the law is allowing you to take it for. And then reduced leave, again, the employee is still working, but their schedule looks a little bit different because they're on paid leave for the time frame that they're asking for. To now get into kind of what is the eligibility requirements and what do I need to do as a worker and what do I maybe need to do as an employer. So for employees, you have to provide notice, and obviously in emergency circumstances, it might look a little bit different, but generally employees do have to give notice. We put in the proposed rule reasonable notice to be 30 days, but I will put a caveat on that it's pending final adoption of the rule. But after, a lot of research and the public comments and basically any other state that has paid leave, 30 days seem to be the general consensus. But again, that's pending final adoption of the rule. When you as a worker are trying to schedule leave to do that. Proof must also be provided on one of the reasons that you're taking leave for. So this is something that we'll continue to develop later, especially as we get to 2026, what proof you need to provide. So if you're applying for medical leave, which is for your own medical needs, that might require a medical certification. For any other types of leave, the form or the proof might be a little different. So I would definitely say continue to keep just staying informed in terms of what the program is doing. And especially as we, again, get towards 2026, we hope to have a much more clear um, way or information to share with folks about that proof that's needed. There's also an earnings requirement that is tied to this program. So an individual must earn 6 times the state average weekly wage in order to access the benefit in 4 of the last 5 completed quarters. You might be asking, what is the state average weekly wage? That is a number that is published on an annual basis by the Maine Department of Labor, taken into wage data from both the private and public sectors, and that number and that number essentially leads to the state average weekly wage. I'll talk more about what the state average weekly wage is in a later slide, and definitely happy to address any questions about that. But essentially what that means is the current state average weekly wage now is $1,144. If you multiply that by 6, looking over 4 of the 5 completed quarters, that's what that essentially means. So if you're applying, we take your wage information, all of that into account, again, to determine whether you met that monetary requirement. And then finally, there is, another factor that we have been certainly been talking about or sharing, and that is undue hardship. So the term undue hardship is something that is in the statute. And in the proposed rule, we try to create a framework on what the scheduling of leave means that's not causing an undue hardship onto the employer. We've had a lot of public conversations and debate, and we've had a lot of conversations in the rulemaking process in the form of comments. And so we have carefully crafted, hopefully, what is a proposed rule when it's all said and done, that provides that framework of what undue hardship means. And again, we're happy to answer any questions that come about it. So as an employer, or just for employees too who are on the call, for FYI, there are job protections surrounding this program. So if you are an employee, for example, that has worked for your company for 120 days or more, you are entitled to those job protections. And if you're working for someone under 120 days, the employee is not going to be guaranteed those job protections upon taking leave. That job could either be the exact job that they had, including the benefits and any other benefits that they were given prior to taking leave, or a job that's equivalent to the one that they had prior to taking leave. So they can have the exact one or something similar to it, but it has to include, again, like benefits or the same exact benefits that they also had. Employers can also apply for what is called a private plan substitution. So these are, and if individuals are considering this can either be done through a fully insured plan, which means that the employer is purchasing a plan on the insurance market that is demonstrating that I have a plan that's substantially equivalent to the state plan, and I would like to use this option for my employees. Or you can do it through the self-insured route, which essentially means that you as the employer are paying for this paid leave program out of your own pockets and charging premiums through your own developed policy. One thing I will say about self-insured plans, it does need to come with the surety bond as well. For the fully insured plan, it does not, but for the self-insured plan, it does. But if you do apply for a private plan and you can prove that it's substantially equivalent and including meeting any minimum criteria that we have in the rule, what that means is the employer and the employees will not have to pay premiums to the state, but they will still have to comply with any terms and conditions that are either spelled out in the rule or in the law to maintain that substitution. So definitely happy to answer any questions about that. And because if any of those terms and conditions are violated, the department has the right to withdraw that private plan approval, which means the employer and the employees are going back into the state plan, which is that's essentially what that means if it's withdrawn. And then finally, there are notice requirements for the employer as well. And so we're happy to talk more about the poster, which we now have available online actually on our webpage on paid family medical leave. You can find it under the employer resources tab. And that is where you know, they can be hung in typically what are in break rooms across the state. But I would encourage folks, since that poster is available, especially from employers, to employers, is to post that poster as soon as possible, especially given premiums are going to be coming out in early January. So it just gives employees the opportunity to learn more about paid family and medical leave. And then they should hopefully have a somewhat better understanding, but if they have questions, they can always reach out to us. But if the employer does not provide notice about the paid leave program, the employee's right to notify the employer about the scheduling of leave is waived. And that is something that's part of the statute about that employer obligation on notice. I would also encourage folks to look at the law when it comes to notice as well, because that it just, as the employer, just gives you a much more well-rounded understanding of what the notice requirements are, so that you're in compliance. So you might be asking, okay, I'm paying money into the fund. What benefit am I getting out of this? Good news is you're getting a benefit. It's going to be based on a two-tiered wage system. So I'm going to try to explain this because you see a lot of terms that involve the state average weekly wage. So individuals, after looking at your wage information as the applicant that you provide to us, if your wage is at or 50% of the state average weekly wage, you're going to receive a 90% wage replacement for the program. If your wages are more than 50% of the state average weekly wage, that could lead to an additional 66% wage replacement. And so when you tie the tier 1 and tier 2 benefits together, that's essentially your weekly benefit amount. And then the benefits are capped at the state average weekly wage, which again is a number that's published by the Department of Labor. In 2024, it's $1,144. By the time people apply for this program in 2026, that number might look different. But the tier 1 and tier 2 formula is part of what we have hopefully made sense in the rule. But that's how we calculate the benefit amount. So try to put all of these equations and all of that into hopefully simpler terms. We provided 3 examples in the next 3 slides. So this is one example of someone who's earning about $57,000 a year, so Morgan, and she needs to take 8 weeks off to care for her mother with a serious health condition. So this is probably more family leave. You'll see Morgan's weekly wage, you know, by dividing that by 52 weeks. And then you'll see how much she's paying into the fund a year. So she's paying about $285 a year for paid family medical leave. And because Morgan is working for someone with less than 15 employees, that employer does not have to pay essentially the $5.48 a week, or essentially match it as well to pay into the paid leave fund. So all of the deductions could come from her pay. Again, trying to make sense of what tier 1 and tier 2 wages are. We looking at a 90% wage replacement, she's going to earn about $514. And then because she's making more than the state average weekly wage, more than 50%, she's going to receive an additional 66% wage replacement. So again, tying the tier 1 and tier 2 wage replacement benefits together, $859 is what she should be receiving for the next 8 weeks. So we look at someone who has a different income scale. And in this case, Michael earns about $35,000 a year, and he's going to need to take 6 weeks off to bond with his newborn daughter. Again, you'll see what his individual wage rate is, which is a little over $670 a week. you'll see how much how much is being deducted from his pay per week for paid leave. And then because Michael is working for an employer with more than 15, that employer is also paying 0.5%, so $3.36 per week. And then again, you'll see the tier 1 and tier 2 wage replacement. And then finally, you'll see what his benefit amount is for the next 6 weeks. So it'll be around $580. And then the last slide, and this is to kind of hone in on capping weekly benefit amounts at the state average weekly wage and what all that means. So Joe is earning about $90,000 a year. They need to take 4 weeks off to recover from surgery. Again, you'll see what their wage rate is, how much is coming out of their check for paid leave, including the employer's contribution because they're working for someone with 15 or more employees. And then you'll see the tier 1 and tier 2 benefits. And then you might be going, well, wait a minute, they're earning $1,278. Okay, great. However, the law requires us to cap it at the state average weekly wage. So if Joe was applying for this program now, they would be earning, obviously they'll be earning on the higher end because of their wages, but it's going to be capped at $1,144 for the time that they're on leave for the next 6 weeks. So with that, I will stop sharing my screen if this is the appropriate time to do so, and see if there are any questions. Or I can leave it up, Shannon. I'm happy to defer which option to go in.
Yeah, thank you so much. Thanks, Reggie. So yes, we do have a few kind of specific follow-up questions for you, but if folks have other questions, this would be a really good time to start putting those in the chat for us too, please. So Reggie, you know that we had some specific questions about how this might apply to worker cooperatives.
Yes.
So I wanted to see first if you can let us know, is there any distinction under this new law between a traditional employee and a worker owner of a cooperative?
So the law does not distinct or have a distinction between the two because it really kind of comes down to if you're earning wages. So if you are a traditional employee that's earning wages, yes, it's going to be likely that 0.5% is going to come out of your pay. But one thing that we have learned in talking with Shannon and Emmy about co-ops is the profit distribution. And that's where we don't know. And that's where we actually have been trying to research that question in terms of whether premiums are going to be coming out of any profit distributions that you have. So we will continue to research that question. And then hopefully if we do come up with an answer to that, we're able to provide that as soon as possible. But we know that that is a good question that we did not contemplate, but I'm glad that it was raised to us.
Great, thank you. Yeah, sometimes those cooperative questions kind of bring up more questions that folks aren't expecting. Right, because we also were wondering, and and this may be more of a bylaws question for cooperatives, but like how taking leave could affect distribution, just sort of in the other direction too, which are pretty interesting questions, but it sounds like we're still working on finding answers to those.
Yeah, on the profit piece, yes.
Could you talk a little more, please, because I know that you shared about hours worked and state average weekly wage. Can you talk a little more, though, specifically about how this will affect part-time workers and especially seasonal workers?
Yes, so this will affect both part-time and seasonal workers. So again, taking what we hoped captured the intent of the law was to capture as many employees and employers as possible, regardless if you're full-time, part-time, seasonal, temporary, intermittent employees. Those employees are going to be affected by the program, meaning that premiums could be deducted from their pay. Essentially workers, regardless of how they worked and including FTEs, are going to be impacted by this as well, in terms of premiums being deducted.
Okay. And so for seasonal workers, um, they would still be bound sort of by that 4 out of 5 quarters
Yeah, in terms
rule.
of the earnings, yeah. So in terms of the earnings and if they're applying for leave, and then we know we know seasonal workers and really any worker, to be honest, has more than one, could have more than one job. So when they're applying for leave, they can give us, they can provide us with that wage data if we don't have that wage data on file already, because on the unemployment insurance program might be helpful to obtain that wage data because they already have it. So seasonal workers could still be eligible, but yeah, it would just depend on what their earnings are, taking into account all of their jobs if they have more than one.
Okay. So it would be earnings specific to the worker and not specific to the worker at one particular job from
Yes,
which they're
yes,
taking leave.
yes.
Great. Thank you. Thanks for that
Mhm.
clarification.
Yeah,
I don't think I had caught on to that.
yeah. No, it's a good
Excuse
question
me.
because yeah, a lot of people have asked, well, is it tied to a job? And the answer is no. Yeah, it's all wage data from all the jobs that they worked in that time frame.
Okay.
Yep.
Makes sense. Thank you. And I know that you said that there are specific job protections for folks who've worked
Mhm.
120 days at the job from which they're taking leave.
Mhm.
Are there other specific uh, job protections for folks to protect them against retaliation or discrimination when
Yes.
requesting leave?
Yeah, and we have to flesh this out more. I think, yeah. So essentially, the answer is yes. So employers can't retaliate against an employee for applying for leave, the intent to use leave. Yeah, that's prohibited in the statute. And then kind of also going back to the right to accrue benefits, so which I guess could be one form of job protection. So, and if an employee is to take leave, the employer still has to maintain that employee's health benefits and any other benefits that they had before they took leave. So things should be there when they return, whatever they had before.
Thank you. And if employers or employees have questions along the way, who's going to be the best resource for them to
Yeah,
reach
and
out
so
to?
yeah, so I would encourage folks to reach out to the Maine Department of Labor. We do have I'm blanking on the number, but it should be available online. I think it's 207-623-7900. Actually, I do have it. And that is the number where you can call the department, and then any questions that do arise will get routed to someone on the team. And we do try to get back to folks pretty quickly. But most of
Thank you.
also our information too is posted online on our webpage. But again, if that still leads to more questions, they can always call the department.
Thank you. And as employers are bringing this online and starting to work with employees or with worker owners, are there other additional supports or accommodations that you think cooperatives will be able to offer to their worker owners who are taking leave? And I'm thinking especially like with varying compensation structures. Are there other ways to make this work for individual worker owners?
Sure. I mean, I guess that would kind of maybe pushing the answer back. I mean, that would depend on what the employer's available resources are to help support employees on leave. And this is actually leading to another thing I didn't think about before. So if there are certain, so essentially an employee or an employer could supplement an employee's wages. So I guess that maybe that is one way to support them. So if, for example, if they're using short-term disability, and I'm unfortunately I'm forgetting what the other reasons that you could supplement their wages that won't reduce their benefit, unless they're on unemployment or workers' compensation. That is where we are required by law to reduce their benefit amount. But otherwise, it will be left up really to the employer and what their resources are available to do so. And if the rule allows for supplemental wages to be given, then that pending final adoption of the rule, that could be one way to do that.
Thank you. I'm wondering if folks have other questions. We do have some time. Seeing anything in the chat.
Yeah, it's a lot to absorb in probably 25, 30 minutes.
It is.
Yeah, it's a lot. And we understand that, but you know, I would just, as a plug, as if any more questions come in the meantime, I would definitely encourage folks to go on our webpage, you know, www.maine.gov/paid leave, and right at the homepage, you'll see a get notified box right at the homepage. I would encourage folks to put in whatever email address they would like and complete the hopefully what is a pretty straightforward process to sign up to be subscribed on any updates that come out from us on paid leave. That is one way to stay informed. But again, we're happy to answer any questions now in the meantime.
Thank you. I do see a request to repeat that phone number that you just gave us,
yes.
Reggie.
Yes. So this is from memory, so you might have to go online from the website, but I believe it's 207-623-7900. And that will that's the general phone number for the department, and that, you know, they have been great at forwarding us questions and emails from us. But I would verify that by just Googling Maine Department of Labor, but I think that's the number.
Thank you.
Yeah.
I do see one question in the chat. It says if an individual works for more than one, it says employee, but I'm wondering if that should say employer. Who would do the leave paperwork?
Yes, so that's a good question. So I guess that would depend on what the employees do. So that's a very good question. So if you have two jobs and one employee, you've given them notice, I want to take leave from that job. The other job that they're working for doesn't necessarily have to do the same paperwork. They don't have to be notified. At least we don't think they have to be notified. Any paperwork that needs to be done is probably mostly going to be done by the employer. I'm sorry, mostly by the department. So in terms of applying for the benefit, the medical certification and the authorization, all of that will likely have to be done by the applicant itself. But if an employee has two jobs, they just need to notify whichever job in terms of scheduling the leave that they're taking. We don't believe that there's an obligation for that employee to notify the second employer, because they're not taking leave for that second employer. We're only focused on what the employer that they are taking leave for is doing. But the employer, we don't envision should have a huge administrative burden on them in terms of applying for the program. That should mostly be on the applicant or the employee.
Thank you. But if in that scenario, if the employee were taking leave from both jobs, they would need to submit paperwork for both?
Yeah, they would need to do notice to both. But again, we know, you know, and it's almost hard to predict what employees are going to do until we get the information. But yeah, if it's both employees, then they would have to provide notice to both. But if it's only one employer, and they know that's only going to be one employer, then they only need to provide notice and fill out the paperwork for that employer as the applicant.
Thank you.
This is a good question.
So I see another question. Does this program replace Maine's unpaid family medical leave law? Would there be situations where someone qualified for unpaid leave but not paid leave?
Yeah. So it doesn't, the legislature, when they crafted paid family medical leave, didn't necessarily get rid of the Maine unpaid leave, but this question also kind of goes to concurrence. So Maine, any unpaid leave in terms of FMLA or Maine paid leave does run concurrent with paid family medical leave. So for example, if someone in 2025, and this is in the proposed rule, so again, this is not final, but in the proposed rule, we said if an employee in 2025 uses 6 weeks of, let's just say, FMLA, And in 2026, they decide, oh, I need to take paid family medical leave. Whatever time that they used for either unpaid leaves, either federal or state, does impact how much leave time they have for paid family medical leave in that year. So if they've used 6 weeks in one of those programs, or 12 weeks, or however long, it is going to impact how many weeks they have left for paid family medical leave in the following year. So, because we've heard the concern about, what happens if people take unpaid federal, unpaid state, and paid family medical leave. And that was in response to comments. We had that proposal.
Yeah. And then we got the question, so who submits the paperwork to the department? Is it the applicant or the employer?
In terms of applying for the program? Yeah, it'll be the applicant. So,
Okay.
yeah. So, and I guess the beauty of, things not going into effect in 2026 is we still have time to flesh out what that process is, but it'll be the onus to apply for the program will be on the employee to the department.
Right, because the contributions start next year, but
Yeah, right.
the
And
leave
so
begins in 2026.
yeah, and in 2026, when benefits go live and applicants say, oh, I might need to take paid family and medical leave for whatever qualifying reason, well, hopefully we'll have a system ready to go that will give them, the foundation of what they need to provide us to determine whether that claim is valid.
I'm wondering if you can talk a little bit more about what would justify an undue hardship for an employer.
Yeah. Yeah, I laugh because I know this is going to be tough. And so the framework of undue hardship, I would encourage folks when the rule is finalized to look at those factors. It is depending on what the employer's, I think, in part needs are. And this is going to be, I think, a conversation that is, this is going to be an untested thing, this undue hardship concept. So I guess my answer is I would look at the final adoption of the rule to determine the framework of what an employer could claim as undue hardship, but it would be in the context of whatever business that they're in, whether it's, it would be up to the employer's determination, looking at the context of their business in part. But again, I would look at that framework and the rule.
Okay, and who ultimately will, once the rules are published, who would make the decision as to whether or not an undue hardship is truly an undue hardship?
Yeah, and so at this time, it would, I guess that's a tough question to answer right now, to be honest, because one, we have heard a lot of comments around it should be left up to the department, and then other comments saying that it, should be left up to the employer. And so we're still fleshing through that. And so I guess that's the best answer I can provide. But it's a good question.
More to come.
Yeah.
I see a question in the chat. Are there considerations for monitoring if there is a question as to whether abuse of the program is occurring?
In terms of does the employer have an obligation, or is that the onus on the department? I don't know if what the question.
I think that's the question is
okay.
how will it be monitored?
Oh, yeah.
Make sure there's not abuse happening.
Oh, right. So every year as part of the data reporting, that we will report if there have been any instances of fraud or abuse that's happening within the program. I'm trying to think of anything in the statute that, I guess I would say, actually, I do know the answer to this now. So it's not in statute, it's in rule. So when an employee applies for the program by statute, within 5 days, the department has to notify the employer that a claim has been filed. So the employer is going to get that notification off the bat. Then we put in the proposed rule that we're going to put that claim on hold for 10 days, essentially allowing the employer to weigh in on whether one, well, is that an employee of mine? That might not be an employee of mine. And that's one way to prevent that fraud and abuse from happening. Or potentially any undue hardship claims that come out, as a result of the employer saying the scheduling of leave is going to cause an undue hardship because of this reason. So that 10-day hold is one mechanism of determining and preventing fraud and abuse in the program. And then after we've determined, okay, there's no fraud, there's no abuse, that is the employer's employee, then we'll move that claim forward. So hopefully that answers that question. Yeah, sorry, it took me a while to think about. Yeah, we do have mechanisms in place, and that is both in the statute and in the rule to prevent fraud and abuse.
Thank you. It's also probably challenging to think about those questions before the rules have been completely finalized. So
yeah, but once the rule is finalized, sorry. Yeah, I was gonna say, once the rule is finalized, that will give folks a framework of, okay, this is how they're going to review the claim in terms of that 10-day hold, and then, the other aspects of the rule too.
Oh, that's a great question. Are benefits going to be considered taxable income to the employee?
Oh, yeah, that is a great question. We are waiting on a determination from the IRS about the taxability of benefits and premiums too. Excuse me. This is something that every paid leave state is currently waiting on. So at this time, I don't know what the state's going to do in terms of taxability of benefits, but I know that most of our questions most of our answers are pending guidance from the IRS. So that's a very good question.
Do we have any other questions from folks?
Oh, actually, and to add more to that, other states, as we're waiting on guidance from the IRS, they have done either the voluntary, the employee could voluntarily deduct either 5% for the state or 10%, whatever state tax bracket that an employee is in. For Maine, it's going to look a little bit different, but people have done voluntary deductions, and that has led to a 1099 form based on our research from other states. But it would be good to know what the IRS does, and I would also keep an eye out on anything that the state of Maine does separate from the federal government. But at this time, we don't know of anything.
Okay. Any other questions for Reggie? I feel like the math of figuring out what someone's benefits will be when they take leave based on that average weekly wage is seems like it could be confusing. Are there plans for any sort of like a calculator to help folks calculate that?
We're internally discussing how to do that. And to also put a disclaimer out that, like, this is just an estimate, but it is something that we are thinking about, because the weekly benefit amount is going to be based at the end of the day on what that individual employee has earned on a weekly basis, kind of taking into account that very complicated two-tier math formula. But yeah, we definitely are continuing to try to find a way to put out a calculator for folks for better understanding.
I feel like that would be really, really valuable. It's a lot of math, particularly for folks who may be staring down a significant medical issue or family concern. So
yeah,
take a little of the worry out.
Yes.
All right. Just giving us another moment to see if anyone has any other questions. I'm not seeing any. All right. Well, Reggie, any other closing thoughts for us?
Yeah,
Anything
I would
else?
just, yeah, first of all, I would just say thank you for spending the last hour or so with us to talk about paid family and medical leave. But I would, again, encourage folks to go on our webpage, learn more, sign up to be on the interested parties list, and then just kind of stay in tuned about where things are happening. And we're doing an exciting public education campaign right now on paid leave, and we have one more employer-related webinar to attend to at noon. So that's part of our ongoing education, but definitely encourage folks to sign up for the interested parties list.
Thank you so much. And again, watch your email. You'll be receiving a recording of this webinar along with some links to resources. Um, You'll also receive a link to the survey, and I see that Emmy just posted the survey in the chat. So please fill that out. Your honest feedback will help us to keep developing great webinars that are really of interest to Maine cooperatives. This series of free webinars will continue on October 30th with Navigating Health Insurance for Maine Co-ops, Tailored Solutions for Cooperators. We're going to be joined by Matthew Sear from Wheelers Insurance and Maddie Tadrika from the U.S. Federation of Worker Cooperatives to explore the health insurance landscape with a focus on Maine's cooperatives. And then on November 6th, we have a bonus webinar. Cameron Monahan from CEI will present Securing Your Future, Understanding Maine's State-Run IRA for Co-op Employees. Cameron's going to be talking about Maine's Retirement Investment Trust, or Merit. And so we hope you will all join us for both of those. I just want to say thank you again so much to Reggie and Sophia for being here, for helping us learn more about paid family medical and medical leave in Maine. Thanks for going through all of that with us and answering all of our questions. And thank you to all of you so much for joining us. We really hope that you enjoy the rest of your day. And please remember to fill out that survey.
Thank you, guys.
Thank you.